picked an empty, closed parking lot to eat your tacos?
How far away is Taco Bell? Oh, you can see it. This is going to be better for the video. You can see Taco Bell.
Is there a reason that you picked this parking lot, though? But you couldn't go home?
I'm not going to answer any of your questions.
How you doing, sir?
Howdy.
What you got going on, brother? You know you're part of a closed business, right?
Can I show you?
Yeah, absolutely.
You're familiar with this brand?
No.
You would identify that brand as Taco Bell?
Okay, I see the order ahead. Okay.
Yes, yeah. You see the consumed Taco Bell in the bag?
Yeah.
All right, we're doing some detective work here, right?
Okay.
And if you turn behind you, there's a Taco Bell, and so I drove from Taco Bell, and then I ate my Taco Bell.
Okay.
And I was in the process of eating my Taco Bell when I was stopped by your officers. So, am I free to go?
Well, not right now. We're trying to get your information from you, sir.
What's your name and badge number?
It's Sergeant Baldwin.
Ridiculous.
This is a closed business. It's considered loitering and prowling. You can't be part of a closed business if you're eating your food or whatnot.
We'll get into that.
The thing is, when they ask for identification, you're supposed to provide it.
Am I free to go?
No. You got identification on it.
I'm literally not going to answer any of your questions, so am I free to go?
Alright, I'm going to start it.
Alright, you have the right to remain silent. Anything you say may be used as evidence against.
Welcome back, everybody. As many of you guys know, I'm a law enforcement trainer and instructor. I train and instruct military, law enforcement all across the country on various law enforcement disciplines to include constitutional law, case law, patrol tactics, use of force, etc. And here is, this is just, let me just first say, we don't have the full context. I have not been able to find the full video, but we'll just talk about what we have going on in the clip that we do see. And I do admit, it's very concerning. So we see that there is somebody who is parked in, and what's not contested is that you have somebody in the vehicle, occupant in the vehicle, that is parked in a closed business in a parking spot while consuming Taco Bell, while eating Taco Bell, which from what we can gather is literally in a very close proximity. Maybe it's across the street, but it's very close wherever this Taco Bell is. So it's reasonable to think from everybody that responded and according to the person, the occupant in the vehicle who's talking, that this individual went to Taco Bell, paid for services, got food, and then parked very close by to consume his Taco Bell. And so we got a couple things here, right? We have police officer, we have multiple officers, including one sergeant who is trying to stop an ID, and they do proclaim emphatically, without equivocation, that he is currently detained. So about what is requirement for a detainment. You guys have seen this many times before. Here we have it. Brown v. Texas, 1979. The Supreme Court has affirmed that law enforcement needs reasonable articulable suspicion of a crime in order to detain and compel someone to identify themselves. Okay, so that's pretty standard. You hear me talk about that case law a lot. But it's important. In order to detain somebody and compel identification as a police officer, you have to have RAS, reasonable articulable suspicion, and that is flushed out by the Supreme Court case precedents. The next thing we have to kind of consider is this person engaged in a lawfully constitutionally protected activity, right? And so I like to talk about the flag burning Supreme Court case precedents. Texas v. Johnson, 1989. The Supreme Court has held that flag burning constitutes symbolic speech that is protected by the First Amendment. The Supreme Court further held that freedom of speech protects actions that society may find very offensive, but society's outrage alone is not justification for the suppression of free speech. Now, with that being said, is eating covered under free speech? No, not exactly. But if we look at this with nuance, we look at this with common sense, I do believe, again, and I'm going to speak from my personal lived experience here, and this is obviously going to be, my opinion. So let me just state this is my opinion. But I believe, in my opinion, based upon my training experience, based upon my knowledge of case law, being from my academic endeavors, my personal life experiences, and the education that I've received therein, I think that a lawyer worth half their salt would be able to articulate that consuming food is a protected activity in which lawful citizens of the United States of America may partake in. I know this sounds crazy that we even have to talk about this, right? This is obviously, you guys are probably looking at me like I'm crazy, but obviously we have to talk about that because that is the contentions that's the contention that we have here. We have somebody who is factually consuming Taco Bell And we have to, if we want to have any nexus to whether criminality is at foot here, we have to understand the facts, the totality of circumstances pursuant to accordance with Illinois v. Gates, right? We have to understand the totality of circumstances, which means we have to talk about the consuming of Taco Bell. And I do believe, again, this is my bias and this is my personal opinion, and I don't mean this to make light or be funny. I mean, just we honestly have to talk about the steps here. I do think that a lawyer would be able to articulate that consuming food, lawful food, that was lawfully purchased within the vicinity of the area that person is contacted and apparently detained, I do think that a lawyer would be able to articulate that is a protected right. Okay, again, I'm assuming, and the officer's outrage at this person lawfully consuming food in a parking lot that nobody is at, closed business at that, in a public space, I do believe that would be protected. Again, let me just caveat that with, that is my opinion. Again, and I know you guys are looking at me like I'm being weird here, but I mean, factually, if we expect this to play out with adjudication, right? If that officers do decide to go hands-on and make that arrest, the totality of the circumstances are going to matter. Therefore, that nexus to that activity will come up in court and will matter, which is why we have to talk about it. As crazy as it sounds. So let's kind of go into this loitering, because loitering is what got brought up, right? This you were loitering and prowling. So let's talk about that. Based upon what I can find, statute-wise, you have it right here in front of you. Loitering or prowling, Florida statute 856.021. These are the jury instructions. So these are the elements that are going to have to be proven. So let's say this was in Florida, for example. The defendant loitering or prowling in a space at a time or manner not usual for law-abiding citizens. Again, I think that's a stretch. I think it's very reasonable for a law-abiding citizen to be lawfully consuming food, which I believe is a God-given right. Again, my opinion, I believe consuming food, drinking water, I believe this to be a God-given right that we are allowed, right? If we're allowed to protect ourselves, we should be allowed to feed ourselves. Again, this is not hyperbole here. I'm being honest. We got it. Again, totality of the circumstances pursuant to accordance with Illinois v. Gates. 2, such loitering and prowling was under circumstances that warranted, justified, reasonable alarm or immediate concern for safety of persons or property in the vicinity. Again, the concern for public alarm, I don't see how anybody could reasonably articulate the immediate concern for the safety of persons or property in the vicinity. Again, you would have to be able to, at least at a minimum, articulate criminality at foot. And if the idea is, well, this person might finish consuming their food that they are lawfully protected to do, my opinion, that is a God-given right, and then they may decide that they're going to commit a crime after they get done doing their lawfully protected activity. Make that make sense. I can't. Maybe this officer can. I can't make that make sense. And so circumstances that may be considered in determining whether such alarm or immediate concern is warranted. A person takes flight. That didn't happen. Person refuses to identify himself. As we know, based upon, Texas v. Brown, 1979, there has to be reasonable articulable suspicion in order to compel identification. None of that seems to be in play here. And then manifest endeavors to conceal himself or herself or an object. That's not the case. Unless flight by the person or other circumstances makes it impractical, a law enforcement officer shall afford the person an opportunity to dispel any alarm or immediate concern which would otherwise be warranted by requesting him to identify himself or explain the presence and conduct. Obviously, nobody there is arguing or articulating that this person is not consuming Taco Bell. There is a Taco Bell right across the street, right? So again, I think this individual, at least in my honest opinion, has done everything that they would need to do, which they're not required to do, to dispel any alarm or to dispel any articulation of a crime. Unless there's other extenuating circumstances which are not presented in this video, I don't know how that person would do that. No person shall be convicted of an offense under this section if the law enforcement officer did not comply with the procedure or appears at trial that the explanation given by the person is true and believed by the officer at the time would have dispelled the alarm or immediate concern. So there you go. That completely just shuts that down completely there with that last statement. Now, this is a Florida statute. What does the Supreme Court say? Well, we have a Supreme Court on loitering. Okay, and that is Chicago v. Morales, 1999. The Supreme Court affirmed that the city of Chicago's loitering ordinance was unconstitutional. The Supreme Court affirmed that a criminal law is unconstitutionally vague if an ordinary person could not understand what conduct is criminalized, and if the vagueness of the law encourages arbitrary and potentially discriminatory enforcement. I think you have that 100% here. This, in my honest opinion, again, you're not asking for my opinion. I'm just going to give it for the sake of the nexus of what we're talking about here. This looks like contempt of cop to me. That's what it does. And also, it doesn't seem, and maybe there could be other factors here, but it also doesn't seem that the officers have used really any of their investigative prowess in this as well. I mean, it doesn't seem like they have even attempted to use other means, right? So if I have a person who's not wanting to identify themselves and is not wanting to do X, Y, and Z, well, I'm not going to get myself in that situation without reasonable articulable suspicion. Another thing, there may be other ways that we can get this identification, we can get this information, right? Kansas v. Glover states the Supreme Court case precedents that law enforcement officers are allowed to query license plates. They're allowed to. That's within the constitutional parameters, even when there's no reasonable articulable suspicion. A police officer can query any plate in public. So if the officer wanted to, again, they could query the plate, they could see who the registered owner is, and then they could run that person, for example, for wants and warrants. That is 100% constitutional, right? That's been deemed constitutional. Again, Kansas v. Glover clearly plays that out in Supreme Court case precedents. That's just one example. If the person's there's nothing that says the officer can't, walk around the vehicle, look at the vehicle. Again, everything that the officer would have in open view doctrine, plain view doctrine, pursuant to in accordance with United States v. Harris, would be permissible again. And so, this is one of those situations where I'm not seeing what the officer's saying. I don't understand what the officers are trying to make a claim against here. And there's other ways that the officer could have went about getting the identification or could have at least exhausted those means. I don't know if those means were exhausted, but it doesn't seem like those attempts were made. And then lastly, I mean, if you don't have a crime, you don't have a crime. It's very clear that the fact that the person said no was going to be the end-all, be-all. And I don't know if that's a maturity thing. Again, I don't know. On the officer's part of it, I don't know if it's a maturity thing. I don't know if it's just contempt by cop or just lack of understanding and training. And it could be a culmination of all three. I can tell you, as a task force sergeant who does investigation, who does very high-end investigations, there are many times I'm told no. Can't take it personally, right? There are many times where I want to talk with somebody and they don't want to talk with me. Okay, right? That is when it's up to me to use my investigatory prowess, to utilize my resources, to find solutions to the problems that I have, right? It's called problem solving. And so again, I don't know why this is so difficult. It seems like what we're seeing in law enforcement, and I don't believe this is by and large indicative of law enforcement at large. But it's obviously this video is very concerning, especially the lack of articulation on the officer. And then lastly, let me just caveat this, and I know this is going to be unpopular. Again, I'm not here to be your best friend. I'm not here to be popular. I'm just here to give you the receipts and give you the factual aspects of policing, case law, constitutional law. Another thing, another thing to think about, and I think another thing that's important that we at least attempt to understand is, especially when we're talking about Morales, right? Chicago v. Morales. This is a case law that most officers will never know in their career, right? Unless you are intentionally researching, and unless you are intentionally doing your homework, unless you are intentionally trying to learn case law as a police officer. A police officer, I guarantee you, there are many cops that have went their entire careers not even knowing that Chicago v. Morales even existed, right? I'm sure there's many that have never heard of Chicago v. Morales. And so, I obviously know about this case law because I study case law. I study and I try to be the best at my job as possible. But not every officer is going to do that. And, you can say, well, officers should. They should do this, they should do that. And I'm not saying that they shouldn't. But we also have to look at the real aspects of policing too, and that is there is a lack of training. There's not a whole lot of people that teach constitutional law at all. I mean, outside of going to a college, taking college course on this, there are not very many police trainers in the country like myself that teach constitutional law. There's not very many police agencies out there, or not very many trainers out there that really get into the nitty gritty when it comes to case law. And even with those companies, a lot of them don't teach, for example, Chicago v. Morales, right? That's not something that's taught to them. And so, it's kind of hard to expect the officer who's making, especially a brand new officer, right? An uncertified officer, and a lot of these rural departments in, for example, Eastern Oklahoma are making $14 an hour or less. There are departments in Eastern Oklahoma, for example, that are making $17.50 an hour for certified. And so officers that are making, this kind of money, you can't expect them to be able to dump money into higher level, higher learning, higher education. Right? You can't expect them to give up all their downtime to opening up a constitutional law book and reading it, right? A lot of these guys have second jobs in order to make ends meet. And so I do feel for that aspect. Again, it's unpopular. I get it. I know you're going to tear me up in the comment section below for it. That's fine. My only job is to bring reality to the situation and bring reality to what we're actually seeing, in the field. And so, again, I'll say it again. This is a very concerning video. Obviously, there's a lot that these officers need to be brushed up on. There's a lot that they need to learn, and I'm not going to sit here and say that there isn't. And for those of you watching out there, yes, I do believe that law enforcement needs to have more constitutional law training. They need to have more case law training, and a lot of it, again, for a lot of them, an attitude shift as well. But this is where we find ourselves. Tell me what you think in the comment section below. How would you have handled this? What do you think the officers should have done? What do you think they shouldn't do? I'm curious to know what your ideas on this are. What are your ideas on police training? All the above. I really want to hear what you have to say in the comment section below. If you guys like this content, please like, share, subscribe. As always, guys, long live the Republic.